Hello everybody, it's Miss Yeomans doing a lecture for Medical Law and Ethics on intentional and quasi-intentional torts. So let's start out this particular lecture by talking about what is a tort. So a tort is a civil wrong other than a breach of contract, and basically that is a harm that's against a person where we would typically think of crime being against the state. So we're looking at an individual versus a group or a state or the government, if you will. In most cases, our patients are going to bring forward a tort against us because we've actually harmed them. So this is a case that is brought by the involved individual that's been harmed. So when we talk about the four types of torts, there are negligence, strict liability, intentional torts, and quasi-intentional torts. Now, negligence is a breach of established standards of care, and for negligence to apply here, the four elements that must be established and must have occurred are duty, dereliction of duty, damages, and direct cause. So those four things have to occur if we're going to say that there's been some negligence. Now this is something that we've talked about in a previous chapter, so that was just a small little review. But let's move into the new things here when we talk about strict liability. Strict liability is the relationship to or to ownership of the thing that caused the harm. So this actually exists when a person places another person in danger, even in the absence of negligence. And this is simply because that person is in possession of a dangerous product, maybe an animal, or even a weapon. Okay, so a good example would be if we were to knowingly use a defective product on a patient and it caused them some harm. Okay, the next one is intent. Intent is generally the willful discussion to bring about a prohibited consequence. So in both the civil and criminal law, intent plays a role and basically a key role in determining liability and responsibility. So if a person has knowledge of probable results of actions, the person has intent, and that intent may be transferred to someone else. So that person must meet all the elements of a tort in order to be liable. So let's talk about the intentional torts. We have assault, battery, false imprisonment, intentional infliction of emotional distress, and trespassing. Okay, so let's look at assault first. So when we talk about assault, basically it's placing someone in immediate fear of a harmful touching without consent. So with this, that person has got to be aware, awake, alert, and they actually have to be fearful. So what do we normally think about with this? This is something that typically happens before the action of battery occurs. So assault and battery, you've probably heard those two paired together. So let's talk about the battery. It is basically a harmful or offensive touching of another without consent or without a legally justifiable reason. So it doesn't have to be anything that's malice. It doesn't require malice. Without or absent an emergency, anything touching a patient can be battery. So let's think, what are some things we do that could be considered battery? Well, if you are going to draw blood on a patient, or give an injection to a patient without their consent. That is considered battery. So what's really inquisitive is that it can rise to the level of criminal battery, but that requires an intent to do harm or cause an offense. We don't want to go to that criminal level of anything. Alright, so let's talk about consent. So the main types in healthcare are general consent and informed consent. General consent basically is an individual's permission to be touched. It can be explicit or implied. And basically, explicit is also known as expressed or direct consent. So that patient is clearly presented with an option to either agree or disagree, or to express a preference in choice. So, hey, I can say yes or no here. It's not that big of a deal. We just have to do it. It's not that big of a deal, meaning that it's just one more step in things that we must do. But you guys, if we don't do it, we can definitely be sued. Explicit is usually something that is required when it's clear and documented. Consent is required. This is when we're going to do a procedure. We've got to definitely write out on that permission form, consent form, the information regarding that procedure, defining what it is. You have to tell them what's going on. And we'll get into that in a little bit deeper and different. And then we also want to talk about implied consent, because this is getting into a different type of consent. Implied consent is not expressed so much by a person, but it's actually by their actions. So in the book, it actually talks about where you as a healthcare worker maybe come up to the patient and say, I need to draw your blood. And the patient, kind of looks at you and you say, I'm going to need you to roll your sleeve up so I can draw your blood. And the patient goes ahead and rolls their sleeve up and does that willingly without any kind of force, which we would never force anyway, but they're going to do this without any other prompting. So the patient does the implied consent when they actually roll up their sleeve in order to have their blood drawn or even to receive an injection. So we got to make sure that we're looking at that, we're explaining what we're doing when we're taking care of our patients. We need to obviously get consent, written consent, as soon as possible if implied is the only thing that we get in situations such as life-threatening emergencies. So we definitely want to put the patient's life ahead of paperwork, but go ahead and get that paperwork taken care of once that is done. The other that we want to talk about is informed consent. With informed consent, the treating provider discloses the appropriate information to that competent patient so that they can make a voluntary choice to either say yes or no to the treatment. Now, here's the kicker. The healthcare worker has got to say in detail all the possible risk and the potential diagnoses for having the treatment or that procedure, and if there are available other alternatives that they could choose. So all three of those things have to exist in informed consent. The healthcare provider has got to give details to the possible risk, the potential potential prognosis, and also the available alternatives if they do not want to consent to have that procedure. Very, very important. Those three things right there. Okay. Then we move into false imprisonment. With this is the unlawful detention of a person. And this can kind of get tricky, especially when you're working with mental health. And that's where we see a lot of this. With this false imprisonment, you have to look at these things that must be present. It has to be within a specific area by means of physical barrier, force, or threat of force. And the person must be aware of the confinement. In a healthcare situation, this arises in 3 settings. The involuntary commitment to mental institutions, psychiatric institutions, using restraints, whether they are physical restraints like leather restraints or the soft restraints that you see on patients in the hospital, or chemical, meaning medications. And then when a patient attempts to leave the hospital against medical advice, what we typically say AMA, against medical advice. So let's look at the actual defense against the false imprisonment charges. So in your psychiatric settings, the best defense: show all the requirements of the involuntary commitment, show that they were met. You have got to have a checklist and you've got to follow that to a T. If you do not, you're going to have issues. Like again, as I said before, psychiatric institutions, this is probably one of the biggest areas that you will see false imprisonment charges brought against healthcare workers from patients. If you use restraints, you have got to do this. Here on the overhead it says, with restraints, the best defense is to document your behavior that necessitated the restraints, document the use of the restraints for the patient's own safety, and then the restraints should be the last resort. A lot of people even see this in the hospital. Well, you definitely don't want to restrain a patient unless all else has failed, but it has to be for their own safety. Then we move into discussing what is against medical advice. You know, we've got a big duty to protect our patients and provide them with the best medical care that we can. Of course, practicing within our scope of practice. But what do you do when a patient leaves the facility or doesn't want to follow the direction of the physician? They're doing things against medical advice. Well, you got to be careful and document. So let's look at when the patient is leaving a facility against medical advice. That could be the office or the hospital or an outpatient facility. What we want to do is we want to discuss the possible consequences of leaving with the patient. We can't get in the way of them from leaving. We can't get in front of the doors and put our bodies in front of the door, or even throw up a door that locks and don't let them out. We can't keep them from gathering their belongings. And you just basically can't touch them if they are within their right state of mind. This is a big deal. This, as you can imagine, this poses a problem with patients who maybe are not within their right state of mind and trying to keep them safe. But with our cognizant patients, we can't keep them against medical advice. We just discharge them and document our behinds off. Then we move into the intentional infliction of emotional distress. This involves the conduct that is so terrible that it causes severe emotional trauma in the victim. So let's think about the ways that this could be an issue. It can't be just an insult. This is not inflicting emotional distress that you could bring about charges for. But this does have to talk about and discuss the conduct is outrageous and beyond the bounds of common decency. And that's when it crosses the line where a patient can bring about a lawsuit. Trespassing on someone's land. This really is a big issue for our home health and hospice facilities. So this can happen when someone enters another person's land without consent. Like again, even the overhead says it happens most often in home health. But here's the thing you have to remember. If you do work for a home health care agency or a hospice agency, you as the healthcare professional, you are always a guest in that patient's home. If they ask you to leave, then you must leave. Even if you feel that the patient is just refusing because they don't want to and they're just being difficult, you still have to leave. They can actually call the police department, sheriff's department, and have you removed, and even bring about charges. Alright, quasi-intentional torts. Quasi-intentional torts. These are voluntary acts that directly cause damage to a person's privacy or their emotional well-being, but it's without the intent to injure or to cause distress. So quasi means resembling. So when you say quasi, it's kind of looking like it. It's looking like a duck, maybe. You know that old saying. Basically what we're looking at is defamation, invasion of privacy, and breach of confidentiality, which we are at risk of doing all the time with our patients' information. So defamation, we're wrongfully damaging a patient's reputation. This can be done written or spoken. The written form is libel and the spoken form is slander. When this occurs, it has to be communicated to a third person. Now, the person that's talking about this, they gotta know that it's gonna be false, or they should know that it's false information. But the big thing is, it must be actual harm to a person's reputation. So who could that involve? I mean, I immediately think about us as healthcare workers, physicians, hospitals, all of those. If people were to go out and make false statements on social media about us as a person or the entity that we work for, that definitely can cause some problems. Alright, so some of the statements that are defamatory per se are allegations of sexual misconduct or criminal behavior, allegations that the plaintiff is afflicted with a loathsome disease, and that the plaintiff does not need to prove actual damage to their reputation is the big thing. It's just that it's alleged. It's bad enough. Okay? So what are the defenses against defamation? Here's the big thing I want you to remember. Truth is absolute defense. The truth shall set you free. Alright? So when we see things that are going wrong, when can we say something and not worry about defamation? We have to report elder or child abuse. We have to. And in those cases, there typically is a peer review committee that comes together just to say, yes, this statement was brought about for a good reason. It was not to defame their character. It was to help the patient. Okay? And then also, if you're going to leave one facility to try to get a job with another facility, that previous employer cannot try to ruin your reputation. That would be defamation of character if they were to try to do something negative against you just because they didn't like you. Then we move into invasion of privacy. Now this is really, really big. Alright, so invasion of privacy. Does it make you think of when you were a teenager? You're invading my privacy. Get out of my room. Well, with invasion of privacy, this is unjustifiably intruding on another's right of privacy by any of the following, which is appropriating name or likeness, placing a person in a false light, publishing private facts. Ooh, does that make you think of social media or what? And then unreasonably interfering with seclusion. Now, this is bad. Invasion of privacy is bad. So what I like to remind you guys about, when you get into that doctor's office or the hospital and you're given rights to get into that computer and access patient information, you don't need to go fishing for stuff. You only look at your patient's information and only the needed amount of information. You don't need to go looking into very much of anything beyond what you need to know. You stay in your lane, as we like to say. Stay in your lane, because when you start poking into other parts of that patient's chart, it is being tracked, and you can be held accountable for your actions of invading that patient's privacy. Okay? And then moving on into confidentiality. Oh, is this a big one? We are entrusted with this. So we've got to keep every patient's information to ourselves. You don't even want to talk about it with your coworkers unless they need to know. Not nice to know, but on a need-to-know basis only. And we've got to be careful, because this can not only become a ethical problem amongst us, but it can be very much a legal problem. You can be sued. So be very careful with the information that you're entrusted with by your patients. Keep it private. Don't talk about it when you walk away or when you're at home. This concludes the lecture for intentional and quasi-intentional torts.